office and 26th District State Representative Ken Buckner worked with the Illinois Department of Human Rights and the Illinois Human Rights Commission to put this together. So for this event, they will do, you'll receive a presentation from, Lon Meltison from the Illinois Department of Human Rights, and Barbara Moreno-Pacheco from the Illinois Human Rights Commission. So we'll get started with Juan.
Well, thank you very much. On behalf of the Illinois Department of Human Rights and Jim Bennett, our director, I want to thank both Representative Tarver and Representative Buckner for inviting us to this event. We're delighted to be here, and we're glad that all of you took the time to come out here. So my name is Lon Meltison. I manage our Fair Housing Division over at the Illinois Department of Human Rights. And what I want to do is kind of just go over an overview of what your rights are in housing in terms of fair housing. So right now, I want to do a little bit of an introduction as to what my agency does, and then talk a little bit about the fair housing laws in general, and then get into a little bit about what housing discrimination is, and then closing with a little bit of information about new legislation and contact information for our agency. So I work for the Illinois Department of Human Rights. We are the state agency that investigates and enforces the Illinois Human Rights Act. Under the Illinois Human Rights Act, there's actually two sister agencies that are involved in the process. So my agency is the agency that begins the investigative process and then makes a determination as to the evidence that's discovered in the course of the investigation. And then we have our sister agency where Commissioner Moreno-Pacheco works for, and her agency, and she'll get into more of what her agency does, but in general, her agency adjudicates the cases of discrimination once we have investigated them. So our job is to conduct a neutral investigation to see if there's what we call substantial evidence of a violation for real estate transactions. So we cover both housing as well as commercial real estate. We also handle employment discrimination, discrimination involving financial credit, and discrimination involving public accommodation, which is those places that are open to the general public, like your restaurants, your hotels. And then we also cover sexual harassment and education. Additionally, what we do is part of our mandate is to make sure that all of you know what your rights are. So we have an outreach program where we come out at events like this one to make sure to educate everyone as to what the rights are and what to do in case your rights are being violated. So what exactly is fair housing? Well, I like to think of fair housing as the right of people to live where they choose and to have access to housing and to enjoy the full use of housing free from unlawful discrimination. So what is unlawful discrimination? Well, discrimination generally comes in two forms. It could come in what we call disparate treatment, where someone is treated differently based on a protected class. So generally under those circumstances, we're going to have an action that someone's going to take against the individual, and it's going to be based on a protected class. And I'll get into a little bit about what those actions could be and what those classes are. But then we also, unlawful discrimination includes what we call disparate impact situations. And those are going to be situations where you're going to have a potential policy that's neutral on its face. So on its face, it doesn't look to be discriminatory, but when it's actually applied, it'll have a disparate impact on a certain person of a protected class. So for example, if you have a housing provider who has an occupancy standard that limits occupancy to one person per bedroom, on its face that looks like that could potentially be a neutral policy. It doesn't specifically discriminate against anyone specifically, but it could have a disparate impact on families with kids, because if you're a family with kids, you may need to occupy more than 2 people per bedroom. All right, so who's going to be responsible for following the fair housing laws? Well, first we have the landlords and property owners. You know, those are the people who are renting the properties, selling the properties. I think that's pretty self-sufficient, self-evident. But there are a lot of other individuals who could potentially be respondents in a fair housing case. So you could have leasing agents could be responsible for violating the law. You could have management companies. Neighbors could violate the Illinois Human Rights Act. Real estate agents, lenders or insurers, developers or architects, newspapers can even violate the fair housing laws. And then even your municipality and state government could be a potential respondent in a fair housing case. The way I like to think of it is really what fair housing is, it's a barrier to someone's access to housing. And so when you're thinking about what could those barriers potentially be, obviously someone who owns a property and is refusing to sell, that could create a barrier. But in reality, there are a lot of people that are involved in housing transactions that could put up a barrier. For example, if someone's seeking to buy property and they're not able to get a loan to buy that property, that's going to act as a barrier for an individual to purchase the property. Same thing with cities and municipalities. If the municipality requires the property to pass an inspection before the property can be sold, that can act as a barrier. So the law is quite broad in terms of its coverage. So what are those laws? Well, the three principal laws when we're talking about fair housing are the Fair Housing Act, and that's a federal statute that applies throughout the entire country. The Fair Housing Act is enforced by the U.S. Department of Housing and Urban Development. We also have a state statute, the Illinois Human Rights Act, and this is the act that my agency enforces. And then you have local ordinances like the City of Chicago, the County of Cook, that also have their own ordinances. So a person has to comply with all three of these laws. Now, with the Department of Human Rights, we have a cooperative agreement with the U.S. Department of Housing and Urban Development. So whenever a case is filed with us, and it's also jurisdictional under the federal statute, we're going to dual file that case with both HUD as well as us. So both the federal rights and the state rights will be protected. Similarly, if someone files with HUD, they're going to dual file the case also with us, so both the state law and the federal law will be protected. All right, so we talked a little bit about what are the laws that apply and who the respondents are. What are those protected categories? So remember, when we're talking about housing discrimination, it's going to be based upon someone's protected class. So what are the protected classes? So under the Fair Housing Act, there's 7 protected classes. There's race, color, religion, national origin, sex, which includes sexual harassment, familiar status, and disability. Familiar status is the status of having a child, your child living with you under the age of 18. It also includes a family that, where the woman is pregnant. It also includes situations where someone may have legal custody over a child, like a grandmother who may have legal custody over a grandchild, or it could include also foster care situations as well as adopted situations. So those are the 7 protected classes under the federal law. So what are the protected classes under the state law? We're going to have all 7 of the ones I just mentioned, plus 8 more protected categories. So first you have ancestry, which is going to be a person's ancestral basis in terms of their cultural and religious lineage. So for example, if someone who comes from a Latino or Hispanic background, that's going to be considered an ancestry. It also protects age, which is defined as being any individual who is 40 or over. It includes marital status, which is the status of being married, single, divorced, or separated, or widowed. It includes pregnancy discrimination. There are two protected bases for military status. One is for your military status, which is defined as being a member of the armed forces or a member of the reserves, the National Guard. And then there's also protections for individuals who are discharged from the military under a discharge that's anything other than a dishonorable discharge. So what that means is in the military, you could be discharged either with an honorable discharge, or there's a bunch of other discharge categories, and then there's dishonorable. And so an individual, if they're not discharged honorably, but it's not a dishonorable discharge, they're still protected. And so what's the situation that might involve? Well, if you have an individual, for example, who's in the military, they get injured, and so they're not able to complete their 4-year years of service, so they get discharged early. So that discharge may not be considered necessarily honorable because the 4 years commitment wasn't met, but it's not dishonorable. So in other words, there's no really negative connotation with that discharge. It's just that the person suffered a service-related injury, so because of that injury they weren't able to complete their service, and so they're being discharged. So that person would be protected from discrimination. The Act also protects individuals based on sexual orientation and gender identity. It protects individuals who have the protections of an order of protection. So that might come up with, you may have, let's say, a woman who's living with her boyfriend and she's a victim of domestic violence and gets an order of protection, and then the landlord doesn't want to have to deal with the situation, doesn't want to deal with the order of protection, so they tell the lady that she has to move, that she can't continue living there because he doesn't want to have to deal with the order of protection against the husband or the boyfriend. That would be protected under our Act. And then our most newest protection is protection based on an individual's arrest record. And I'll talk a little bit about more later in my presentation on an arrest record. Now, as I mentioned, there's also local ordinances which may come into play as well. All these different ordinances may be different, so I can't go through every single municipality and every single town, but I just wanted to point out that Cook County and Chicago both have protections for source of income, and source of income includes the status of having a housing choice voucher. All right, so we talked a little bit about what are the protected bases under the laws. Now I want to spend a little bit of time talking about what types of discrimination is prohibited. So first, we have probably the most common, which is a refusal to rent. That's pretty self-explanatory. You know, a person cannot refuse to rent to someone based on any of those protected categories. The laws also protect and prohibit individuals from making false statements of unavailability. So this generally comes up with situations where, for example, a person's looking to rent an apartment, they walk into the management office, and they say, you know, I saw your for rent sign, you know, I'm interested in renting a apartment in your building, and then the manager says, oh no, it's just been rented, we don't have anything available. So then the person doesn't even fill out an application, they go on their way, and then later they discover that that was a lie, that there really was a unit available, and they were just falsely told that it was not available. That would be a violation under our law. It also prohibits steering, which is when an individual may try to steer someone to a different area based upon a protected category. We see cases like that involving race. Someone is looking for a apartment in either, let's say, a white area, a white neighborhood, and the real estate agent tries to steer them towards a different area based on their race. That would be steering. Steering can also be in terms of locating a unit within a specific complex. You may have complexes, let's say apartment complex with 10 buildings. If you have a housing provider who's trying to steer everyone with a disability to a certain building, that could also be steering based on disability. And it could also be steering within the same building itself. So if you have a housing provider who, let's say someone comes to them and they have a family with kids and they want to rent an apartment on the 3rd floor, and the landlord wants to steer them down to the 1st floor because they don't want anyone with kids living above the 1st floor. That could be steering as well. So it could be based on a neighborhood, it could be based on a building or complex, or it could even be based on just a specific area of the building. The Act also prohibits retaliation and interference. Retaliation is if someone exercises their rights under our Act, either they file a charge with us or they complain about discrimination, and then the individual retaliates against them. That would be unlawful. And interference, if someone tries to interfere with someone for exercising their rights under our Act, that could be a violation as well. Also, the Act requires housing providers to reasonably accommodate and make reasonable modifications for persons with disabilities. So the refusal to do that would be a violation. And I'll talk a little bit briefly about what that is in a little bit. And then the Act also prohibits discriminating statements or advertising. So if a landlord puts an advertisement out there, posts on Craigslist, apartment available, prefer someone who's white and male, that would be a discriminatory advertisement. That would be unlawful. All right, so I talked a little bit about a reasonable accommodation. A reasonable accommodation is if you have an individual with a disability, and as a result of their disability, they need an exception to a policy, practice, or rule of the housing provider so that they could equally enjoy the property or to have access to the property, then a housing provider has an obligation to grant that exception unless it's unreasonable. And it's going to be unreasonable if it creates a fundamental a financial hardship for the housing provider, or it requires them to fundamentally alter the services that they provide. But if it doesn't do any of those two things, there's an obligation to make that exception. A reasonable modification is going to be similar to an accommodation, but a modification is going to be a physical modification to the property itself. And that could be either the common areas of the building or the unit itself. So for example, let's say that you have an individual who has a disability who uses a wheelchair, and they're looking to rent into a building, and that building has a step in order to get into the front door. So that person with a disability could request as a modification to be allowed to build a ramp that would allow them to access the building. And as long as that was a reasonable request, the housing provider would have to allow them to be able to build that ramp. Now with modifications, the burden is going to be on the individual to actually make the modification, but the housing provider would have to allow them to do so. So when we're talking about reasonable accommodations, we're talking about exceptions to policies. When we're talking about physical changes to the building, we're talking about reasonable modifications. All right, so we talked a little bit about the protected bases, what types of discrimination the Act prohibits. Now there are a few exceptions, which are called exemptions, where the Act doesn't apply to. So there's an exemption for the rental of rooms in a private home. So under those circumstances, our Act would not apply. So for example, my daughter goes to college up in Minnesota. If I wanted to rent out her bedroom to help pay for tuition in my own home, then that would be exempt. So I would not be bound by the fair housing laws for that rental situation. There's also another exemption, which is for small buildings which are occupied by the owner. This is typically called the Mrs. Murphy exception, but this comes into play when there's 4 units or more. Or, I'm sorry, 4 units or less, and the owner of the property lives in it. So if I own, let's say, a 3-flat building and I live in the basement and I'm renting out the other 2 units in it, then that property would be exempt as well. There's also an exemption for religious institutions. And so that would allow, for example, a Catholic church to run a Catholic nursing home. So they then they're exempt on the basis of religion. So they could require everyone to reside there to be the same faith. Now they can't discriminate based on any of the other protected categories like race or sex or national origin. And then lastly, there's 2 exemptions for senior housing. So the first exemption is for housing that's reserved for people who are 55 or older. So that exemption comes into play. Under that exemption, property is going to be exempt if the housing provider makes sure that 80% of the units are occupied by at least one person who's 55 or older. And if so, then property is going to be exempt on the basis of familiar status. So then they could not be held accountable for discriminating against families with kids. Similarly, there's a second housing for older persons, which is for 62 or older. And in order for that exemption to apply, the property has to make sure that everyone living in the property is 62 or older. All right, so we talked a little bit about what your fair housing rights are. Now I want to spend a little bit of time talking about what to do if you think your rights might have been violated. So if you think you may be the subject of housing discrimination, you have several options. First, you can visit our offices at the Illinois Department of Human Rights. We're located in Chicago at 100 West Randolph Street. We're on the 10th floor. We have 2 intake investigators whose job it is to meet people and to hear what their situation is and to assess whether this is something that is covered by our statute and that we could potentially conduct an investigation into. If you're not able to actually come down to our offices, you could either mail or email to us our intake form, which is what we call the complainant information sheet. That form is available on our website. All you have to do is download it, fill it out, email it to us, or drop it in the mail to us. Or you could simply just give us a call. I have the number on here. It's 312-814-6229. That's our intake number. So if you call that number, you can speak to one of our 2 intake investigators who can get more information from you. And then they could either send you out our CIS form, make an appointment for you to come down, or get all the information we need from you over the telephone. The other option, as I said before, we do have a work sharing agreement with HUD. So you could go down to HUD's office, file a charge with HUD at their office. You could go to HUD's website, file a charge online with their website, and if you do that, then you're also going to be dual filed under our act as well. And then that charge will, under our work sharing agreement, will be referred from HUD back to our agency for investigation. So what are we going to do once we get that charge at the Department of Human Rights? Well, the first thing we're going to do is we're going to determine whether we have jurisdiction over it. And that's going to be assessing, is this something that involves a real estate transaction? Does it involve a protected basis that we cover? Is there an exemption that applies? We talked a little bit about what those exemptions are, and whether the charge was filed in a timely manner. Under the Act, individuals have 365 days to file a charge with us from the date of the housing violation. All right, so now we've determined we have jurisdiction. So now we're going to assign the case to an investigator, and they're going to conduct a fair and neutral investigation into the complaint. We're going to interview all the parties involved. We're going to gather evidence. We're going to request documentation. We're going to try to find out what was the reason that the housing provider took their action. We're going to attempt to resolve that charge from the moment it was filed to the moment that we issue our determination to see if we can get it resolved. Sometimes we're able to resolve the charge through a settlement. Other times we're not able to resolve it, in which case then we're going to make our finding, which we call our determination. Essentially, we can make a determination either what we call a finding of substantial evidence, which is basically a finding that there's enough evidence that this case should go forward, or we can make a finding as to that there's a lack of substantial evidence, meaning we've done our investigation, we've looked at all the evidence, and we believe that there's insufficient evidence of discrimination to allow the case to proceed to the next level. Now, once we do that, what we're going to do is we're going to prepare an investigation report that summarizes the evidence and a determination explaining what our finding is. And that goes out to both parties. Once the parties get that, the complainant has a couple options. If we dismiss the case for lack of substantial evidence, they could file a request for review with our sister agency, the Illinois Human Rights Commission. And at that point, the Illinois Human Rights Commission will handle the request for review, and I'll refer to the commissioner to discuss that process. Additionally, under the statute, the parties have the option, or the complainant has the option to file in state or federal court if they want to proceed there as well. Now, if we find that there's substantial evidence, then what we do is we would file a complaint, a formal complaint with the Illinois Human Rights Commission, and then the case would proceed through litigation at the Human Rights Commission. All right. Yes.
Sorry to backtrack a little bit, but if I can't remember the name of it, but wasn't there recently an Illinois state level law that also created the undocumented status of people as a protected class, or am I thinking that's
under the state law, there's the undocumented is not a status. Under the Human Rights Act, there is a protection for employment discrimination on citizenship status, but that's based on the various categories of people eligible to work in the United States. So it's not, undocumented is not a part of citizenship status protection. I don't know if you're having
national origin. We could pigeonhole it under national origin. You could say that the landlord refused to rent to you or change the terms and conditions of the lease based on your national origin. So you could go that route.
All right, so let's say that we've now went through the whole process, and the question is, well, what remedies are available to the person who's been discriminated against? Well, under the Illinois Human Rights Act, it allows for what we consider to be make-whole damages, which are damages to make the person whole again. And that can include monetary damages, which would include emotional damages for suffering. It could include injunctive relief. It can include civil penalties, attorney's fees and costs. And settlement agreements can incorporate any of these forms of relief as well. All right, now I want to finish with just talking briefly about two new recent pieces of legislation that went into effect, or that will be going into effect, I think, in January, that were passed this year. The first one adds arrest record as a protected basis. So prior to this amendment, arrest record was only protected for employment discrimination. But under Public Act 101-0565, it'll become protected for housing as well. And so that protects a person from being discriminated against based on the fact that they either had an arrest that didn't result in a conviction, or based on a arrest that was expunged or ordered sealed by the court. And it also includes juvenile records as well. Another new legislation which was passed, which wasn't an actual amendment to the Human Rights Act, but it kind of goes hand in hand with it, is the Assistance Animal Integrity Act. And so this law, what it does is it lays out the criteria for what documentation is necessary for someone who's asking a reasonable accommodation to have an assistance animal live with them at the property. So those are two of the major legislations that were introduced and passed this year in the Illinois General Assembly. So with that, that's kind of a general broad overview of fair housing. And so at this point,
I got a question.
Yeah.
Sorry, I got one question. With the arrests, because what you basically said, if you wasn't convicted, but if you are convicted of something, you can't get housing?
It doesn't mean you can't get housing. It just means it's, the protected basis is for arrest record. So a housing provider, it wouldn't violate the law for a housing provider to take into consideration a conviction. But if the person only has an arrest, they cannot take that into consideration at all.
So it's nothing to protect the person who did do wrong and want to start their life over. It's nothing to protect them. So, am I making sense? Oh, I'm sorry. Go ahead. Go ahead.
All right. So, but thank you for those questions. So at this point, I'm going to turn it over to Commissioner Moreno Paschal.
Thank you, Juan, and thank you everyone for being here. I want to thank Representatives Tarver and Buckner for hosting this event for us and for the community. I'm a constituent of Representative Tarver, and I'm really happy to be here today. So my name is Barbara Moreno Paschal. I'm one of the 7 Illinois Human Rights Commissioners. Does anyone know what the Illinois Human Rights Commission is? I'm really glad to be able to teach you something today. I think that's great. So I'm going to give you an overview of the commission, and then whatever questions you have, be happy to answer them. And I'm here with my colleague, Evelio Mora, who is in our Office of General Counsel, a longtime attorney at the state, and he'll be answering the questions as well. So I'd like to start with just giving you a quick overview of who we are. The Illinois Human Rights Act is 40 years old, so it's been around for 40, okay. I thought this was, hold on. Let me just make sure this is connected. Do I need to do anything special to make sure it's connected? Well, I'll keep talking and we'll just keep going forward. So the Illinois Human Rights Act is 40 years old, and when the Illinois Human Rights Act was passed, it was one of the broadest acts passed, giving broad civil rights coverage. And during that time, it was contemplated there would be 1 act, 2 agencies. So you heard from Lon, who is with the department, and I'm with the commission, and Belio's with the commission. So hopefully we'll get the screen up. But in any case, the commission serves important functions because it's a place where people can hear their claims of discrimination. You just heard a lot about protections under the fair housing portion of the act, and our commission comes into play when there's substantial evidence of discrimination under the Illinois Human Rights Act, which includes employment, public accommodations, access to financial credit, education, and sexual harassment, other categories, but we're focusing on housing today. And also, if there isn't a finding of substantial evidence, people have the right to appeal that decision before our body. And so it's an administrative adjudicatory function, and we, the commissioners, are all lawyers, and we know about litigation, and we've had experience in different areas. Thanks, Carter. Hopefully we'll get to show some slides, but in any case, you can get what I'm saying. Thank you. Really appreciate it. So this is what 1 act, 2 agencies, and here are the different protected classes. There's too many to read, but you heard about some of them, and the focus today is on housing anyway. So we have the 2 separate agencies, and we view ourselves as quasi-judicial. So I am not a judge sworn in as a judge, but I am a quasi-judicial officer, and I have a legal background, and so do the other commissioners. So an overview of the commission. It's a neutral forum for resolving complaints. There's different paths to get there, which I'll talk about briefly. We have 2 divisions, an administrative law section, and we have an Office of General Counsel, and Evelio works in the Office of General Counsel side of things. And then I'm one of the commissioners. And the purpose of this act and this commission is to make sure people are treated fairly, that you have the right to access justice in a way that is cost effective. So Evelio is going to talk about some of the benefits of filing a case with the commission versus circuit court. So going into there's a lot of rules and regulations. Let me talk briefly about the commission structure. So I'm one of 7 commissioners. We have a chair who oversees the administrative aspects of the agency and has some policy oversight. He works a lot with the director of the department, Jim Bennett, and their senior staff. The 6 of us work together on panels of 3 to decide cases, whether it's reviewing a decision where there was not substantial evidence by the department, or it was a complaint where there was substantial evidence but it needed to go to a public hearing, which we'll talk about a little bit. And then we have an executive director who oversees the day-to-day operations of the agency. And then here's our org chart, just very briefly. So you see you have a chief administrative law judge, and Evelio, maybe you could talk about a little bit why the commission is different. We have administrative law judges who have expertise in civil rights and human rights law, whereas in circuit court, there may be judges who have had experience in that area, they may not. And we also have administrative staff that support the operations of the agency, whether it's going through the filings or doing outreach and other functions, and the general counsel's office. So the administrative law section, if, say, let's go through an example, say someone had an issue with renting an apartment and they decided to file a charge with the IDHR did its investigation, and it can take up to a year to do an investigation depending on circumstances. They find substantial evidence, and now it goes to the commission. So that goes through the administrative law section, ALS, and judges with experience in these issues, well, one of the judges will be assigned to the case, and they'll go through, kind of like court, you have the opportunity to do discovery. Avila, maybe you could shed a little bit more light about that process, and then there's a determination. And these judges, like I said, have decades of experience looking at this act and interpreting it. And so there's no fees when you go through the department or the commission, so it's free. It's also formal and adversarial when you get to this point. If they find that if you're renting an apartment, you suffer discrimination, you allege that you complain, there's a hearing. There's a process that's like going to court, but it's a little different, and maybe you can shed light about that a little bit. There is discovery, and then there could be deposition. So it's very similar, but guess what? It's free. So there is a ruling after the finding, and the court or the judge will say, okay, here's my recommended order for the commission to approve. And so if the parties don't like that, they can file what are called exceptions, which is requesting a review of that administrative law judge's decision. That's where I come in, and our team, we review those cases. So before we get into this, why don't you just share with the audience some of the differences they could expect to see if they filed with us versus filing with circuit court?
Okay, and let me also plug in a couple of other things. First of all, thanks for inviting me. Okay, I love talking in front of people because I love giving into this information.
He's really knowledgeable, so you're getting really good first up here.
Our agency, again, and excuse the horse, I've been battling pneumonia a little bit and with a nasty flu, so don't worry, I'm not contagious. But basically the commission is made up of two sections, as the commissioner said. It's the administrative law section and the office of the general counsel. But basically it's judges and the commissioners. And I think you've heard from Lon and the commissioner here about something called substantial evidence. Okay, I like to think substantial evidence. Everyone sees police shows here, right? Everyone has heard the term probable cause, right? Okay. What Lon's department does is almost similar. Is there probable cause here? Okay, they do an investigation, they engineer witnesses, they have fact-finding conference, and they make a determination. Now they're either going to come up with substantial evidence or no substantial evidence. The substantial evidence is, hey, there's probable cause here that there was discrimination. No substantial evidence, basically no probable cause. Okay, this is where we come. Basically, the commission is one, a judicial body, and it's also an appellate body. Because cases do get dismissed by the department, saying there's no substantial evidence here. But guess what? You get to appeal that, okay? And where do you appeal it? You appeal it to the commissioners, and you get a panel of 3 commissioners to hear that appeal. They'll review whatever pleadings you file, and basically the department will file their brief saying why the case should still be dismissed, and of course you as the complainants will say it shouldn't be dismissed for the following reasons. The commissioners review the case, make a decision, either to sustain the dismissal or say, you know what, we think the department got this wrong. We think there is some evidence here to proceed to a trial, okay? Now, the department could also find substantial evidence, which means there's probable cause to get a court hearing before a judge. Okay? If you select to have the commission hear that case, you get a judge, not with a robe. Our judges wear suits, they don't wear robes. But for all intents and purposes, it's a trial, and it's what they call a bench trial. Okay? You don't get a jury with us. But for, like I said, all intents and purposes, it is a trial. represent yourself or you get an attorney, we usually recommend you get an attorney because it's like any other courtroom proceeding. There are motions, there's discovery. Discovery basically is the parties exchanging information. Parties have a right to know who you're going to call as a witness. They have a right to say what documents are you going to tender to the judge and so forth. So there's a discovery stage, and then there's a motion stage, and then finally there is a trial, okay, where the complainant puts on their case in chief and the respondents or defendants put on their case in chief, okay. The judge is going to make a determination, but it's not final yet, okay. Win or lose, either party could file exceptions, and what are exceptions? It's another form of appeal, okay? And who hears that appeal but our commissioners, okay? So that's the appellate part of our body, okay? Plus and minuses, okay? As the commissioner said, we don't charge fees. So if you get a substantial evidence, for example, you go into the circuit court, here in Cook County or wherever county the alleged act happened, you go into the clerk's office and boom, they're going to charge you fees. Fees to file your complaint. Okay? We don't charge fees for filing a complaint. It's absolutely free. There's other fees associated with filing in the circuit court. One, you have to serve summons. And that entails the sheriff or whatever county to actually go out there and serve a summons. And that could also entail fees. Okay? You could ask for a jury in the circuit court, but that also, they're going to charge you fees for that. Our services are free. If you file a complaint, it's free. We don't need a sheriff to go out there to serve a complaint. We usually do it by certified mail and have that person serve. Circuit court, it could be assigned to judges who don't have a background in the Human Rights Act. Our judges are walking encyclopedias of the Illinois Human Rights Act. They have years of experience, years of trial experience. So you're getting a very knowledgeable person to hear your case. Did I miss anything?
No, covered the high points. Thank you, Emilio.
Oh, you want to talk now? Okay.
Well, I appreciate that. It's really good. We're almost done here, but I want to give a chance for people to ask questions, and if the representatives want to say a few words, I want to give you a 2-minute overview of our website because this is important. So when we think about access to justice, and we think about how do people know about what this is, before you came in today, many of you did not know that we existed. Please share this information with people. You know, I'm serious, please. We gave you some brochures. We will come out and speak at schools. We'll speak at community centers. We want people to know who we are and that people have rights and that they can go to the IDHR if they have a complaint. So here's our new website. Oh man, Carter, do you remember what you did last time? Because I'm seeing the website here, but somehow it didn't. Do I need to move it over here? Anyway, thank you so much. So we have a new website, and what's nice about it is it gives a very good overview of what we are, who we are, what we do. It has my bio on it. Not that that's important. What's more important is the information. And so if you all know someone who's experienced discrimination, please call the IDHR. It's on the back of that brochure. It's in the brochures in the back. Please call that number. The intake specialist will help you. We are also going out to the community to make presentations, but the website is a good tool, and so does the IDHR. They have a website as well to get information. What's the Human Rights Act? What's the coverage? Where can you go? What's the process expected to be like? We can never promise, you know, a certain time frame for processing a case, but we can tell you, like Gavelio was mentioning, that we have people who are experts in this law who know what this is about, and that the person hopefully will get a fair and efficient process to file the charge and then go forward with the complaint. I'm hopeful that, sorry, you might not be able to see the website, but it's www.illinois.gov/IHRC.
And it's on the handouts
It's,
too.
yeah, the link is on the handout, so please check it out. The IDHR has social media, so you can follow them. We hope to get it at some point soon. Oh, okay, in 30 seconds. Thank you so much. And another thing that, I don't know if any of you are attorneys, but we do have free CLE that we offer every month. Okay, well, you know what? There's a lot that's going on. That's something else. There's a lot of CLE. There's a lot of great events and opportunities. So with that, I will close. And I know you all might have some questions. And if the representatives, would either of you like to say a few words? Yeah. Oh no. One more thing. Avelia's gonna mention one more thing, and then we'll go to questions.
The best part of this whole thing
Okay.
is the commission, not the department, but the commission. Okay, if you ever want to see a trial or see how the ALJs work, or actually you want to see how the commissioners decide a case, you're welcome to come by, because we're a state agency and we have something called the Illinois Open Meetings Act, which means that all our proceedings must be open to the public, with the exception of one little thing. But if you ever want to see how, if you're just curious, or if you just want to spend some time there, if there's a trial going on, you are free as a member of the public to sit there and watch a trial. Or if the commissioners are in panel and they're deciding the appeals or so forth and so forth, you are free to come by and listen in.
Thank you. And our website has information about that, including the times, the locations. The panels are usually on Wednesdays, and you can come. You don't have to say anything. You just show up, watch, and learn.
Actually, they could say something, because
you don't have to, but you
don't have
have
to.
the option of public comment.
Yeah, we have
Yes.
public comments during our meetings, since they're, Public Open Meetings Act allows for public comment. So, you're welcome to say something. You can't talk about, if you have a case before the commission, you can't talk about your case. You can talk about other stuff except your case.
Okay, now I guess it's time for questions.
Yeah, you guys want to read? Okay.
Okay.
Yeah. I guess you can just raise your hand if you want to ask a question.
Yeah, she can finish her question.
Oh, yeah.
Hi, Julie.
Julie?
Well, it wasn't that much. It was only like I say, if somebody has committed a crime and they did get convicted. Of course, some things you do want as a rental to know about, but it's nothing to protect someone. Let's say I just did burglary or something, and and I got convicted on it.
Yeah, so one of the things that could be a protection is a housing provider can't treat people differently.
Okay.
So, for example, like let's say that you have like say a shoplifting conviction from 20 years ago, and you apply for a housing, and the landlord says, well, because you have a conviction, I'm not going to rent to you. But at the same time, they rent it to someone who had a similar conviction, 20 years ago, who was either a different race or sex or didn't have a disability. Then you may have discrimination based upon those protected categories.
Okay.
Because you can't, housing provider can't treat someone differently. So if they have a policy that they're applying that's not uniform, that could be protected.
Okay.
Hi, my name is Helena Duncan. I'm a constituent of the 25th District, which is Representative Tarver's district. First, real quick, I just wanted to ask, are there any members of the public here, other than this group that I came with?
You mean members of the court?
No? Okay. So my question is, I was just thinking about this, and this is so important, and thank you for your presentation. But I wonder how far it will go to have a housing process that is not discriminatory if the housing itself is not affordable. If you have an arrest on your record and you end up, getting housing, and then that housing is 75% or 50% or 40%, some astronomical amount of your income. So with that in mind, why, Representative Tarver, did you campaign promising that you would support the bill to lift the ban on rent control, and then once you got into office, you did the exact opposite and you voted to kill the bill? I want to know why.
It's nice to see you, and I think we got a little Twitter exchange, and I invited you to come to my office and have a conversation. For some reason, the last several months, you declined to do so. I'd be happy to have a conversation with you.
You were not happy to have a conversation with any of the organizers from the Lift the Ban Coalition prior to that vote? People who called your office multiple times. I've got here a stack, you know where we stand, your constituents. I've got here a stack of editorials and letters to the editor published in local newspapers, calling you out.
If you want to hijack a public event, be my guest,